John?
Hello, sir.
We all ready? Okay, thanks again for coming this afternoon on short notice. My team and I have worked very hard, particularly during the latter part of last week, putting a brief together that I'm here to talk to you about today. I wanted to make sure and explain it so that we are able to avoid confusion and misrepresentation. The brief that we're filing with the Oklahoma Court of Criminal Appeals today, in part, asks the court to provide guidance on the many cases where state inmates are attempting to be released from prison because of their allegation that the crimes they committed occurred on historic tribal lands. In general, the McGirt decision by the United States Supreme Court has created a significant amount of confusion, especially with regard to inmates who are serving time in state custody for crimes committed on historic tribal lands. Simply put, we are going to be taking the position that with regard to any of these requests, my office is going to oppose these requests, and we're going to do so based on legal authority and case law that limits the ability of individuals convicted of crimes, limits their ability to relief. The McGirt case does not constitute a get out of prison free card. We are not going to allow our justice system to be exploited by individuals who have murdered, raped, or committed another crime of a serious nature, while the federal government considers whether to rearrest and adjudicate their cases. So specifically, the filing that we're making is in connection with an appeal that Sean Bossy has filed. Mr. Bossy is an Indian on death row for murdering a family of Chickasaws. His position is because his victims were Chickasaw Indians, Native Americans, and the crime occurred on historic Chickasaw lands, the state did not have jurisdiction to prosecute him for the murder of a mother and her 2 children in 2010. So just to underscore that the problems the McGirt case creates are not theoretical, I'm going to give you some details of the crime Mr. Bossy was convicted for. The victims were Katrina Griffin, a 24-year-old mother, her 8-year-old son Christian, and her 6-year-old daughter Chastity. Chastity's body was found in the master bedroom of a mobile home the family lived in, severely charred underneath a pile of debris. A chair had been put under the outside knob of the closet door, preventing it from being opened from the inside. Chastity was burned from the waist down. Her legs were charred to the muscle and bone was exposed. She had a laceration to her right cheek and blunt force trauma on the right side of her skull. The autopsy showed soot in her stomach and lungs. Christian was found with his head partially wrapped in a blanket. He'd been stabbed 5 times in the neck and chest. There was a defensive stab wound on his right forearm, and he had blunt force trauma over his right eyebrow. Katrina, when found after the fire, was lying over her son Christian, and her body was covered in debris. Her body had been burned, and there was some indication it might have been covered with a sheet. She had 8 stab wounds to her neck and abdomen, and blunt force trauma to the right side of her head. Her face was charred, and her glasses were attached to her burned hair. She had defensive incised wounds on her right palm. Although Katrina was left-handed, her right hand held a knife with the blade pointing backwards, facing her body. A pocket knife with a broken blade was found underneath Katrina's body. It belonged to Christian, and Katrina kept it in her bedroom. One thing I believe that we can all agree on is that this was an horrific crime. It is also an example of how important it is for the state to seek justice on behalf of Indian victims who were abused, victimized, and killed by non-Indians. Sean Bosse should never be released from prison, and he deserves to stay in McAlester on death row until he is executed. However, after the ruling in McGirt, attorneys for Bosse are seeking his release on the basis that his crimes took place on the undiminished boundaries of the original Chickasaw Reservation, and the state did not have jurisdiction to try his case. So, the question that is especially important in the Bosse case is whether the state has jurisdiction concurrent with the federal government over non-Indians like Bosse who victimized tribal citizens. We take the position that the state has a right and a responsibility to protect Indian citizens from those who murder, like Mr. Bosse. There can be no good that comes from tying the state's hands when we are seeking to protect Native Americans by exercising criminal jurisdiction over non-Indians. This in no way, in my view, undermines tribal sovereignty. Instead, it is a way for the state to work with the federal government to ensure that tribal members receive police protection and justice when they are victimized. Along with Mr. Bosse's appeal, we are experiencing a flood of requests for relief from inmates challenging their state conviction, attempting to take advantage of the decision in McGirt. Make no mistake about it, my team and I plan to challenge every single appeal of convictions that happened on historic tribal land. In fact, we were in court on Friday in Pottawatomie County, where a judge actually gave us time to appeal his ruling before allowing an individual in prison for lewd acts with a minor to be set free. The attorney for that defendant is attempting to get her out of prison because her crime occurred on a historic Chickasaw tribal land. So, there are many other questions that remain with regard to these cases, and as a part of our filing, we're asking the Oklahoma Court of Criminal Appeals to provide guidance. We're specifically asking the court to clarify how Indian status is to be proven and to put the burden of proving Indian status on the defendant and proving that the location of his crime was within the boundaries of a legal reservation. The position that we're taking with regard to that, we believe, is in the best interest of tribes. Sovereigns certainly should not want individuals who don't have legitimate status as members of their tribe to take advantage of the McGirt decision. Again, this is not an academic exercise. We're dealing with criminals who, if released, could reoffend and certainly re-victimize the survivors of the victims of their crime. As Attorney General, it is my responsibility to take an aggressive and resolute stance to protect all Americans, especially when they are a member of one of our Native American tribes. And I will now be happy to take questions.
General, under the Major Crimes Act, if the Bosse murder had happened or were to happen in the next week, who would prosecute that crime?
Well, the thing that sets the Bosse case apart from other cases in which an individual is seeking to have his or her conviction reviewed, Mr. Bosse is a non-Indian. And so we think that there is a very clear distinction that needs to be taken with regard to cases that involve Native Americans. If the perpetrator is a non-Indian, we're going to argue, and we believe that we can make strong arguments that the state should have concurrent jurisdiction with those crimes with the federal government.
So does the act not speak directly to that? Is there not case law about that?
We think that there is conflicting case law around this issue, and it's our position that it is worthy of us taking the tack that we are with regard to, again, non-Indians who commit violent crimes against Native Americans.
Why are you asking Court of Crimes instead of Supreme Court, US, or federal court for clarification?
Well, the Court of Criminal Appeals is appropriate with regard to the appellate court where the relief has been requested. So that's where I guess these arguments, these cases are currently residing with the Oklahoma Court of Criminal Appeals. So that's where the battle is, and we're going to, again, as I've said, we're going to contest these cases on an aggressive basis and ensure that if somebody is legitimately a Native American and if they fall within the ambit of the McGirt case, they're going to need to prove that up.
So McGirt dealt with one specific tribe.
Mm-hmm.
Do you think that applies to other tribes?
So what we've said in the filing that we're making today is that we're hopeful that we win this on procedural grounds. We would prefer that the Court of Criminal Appeals refer this issue of whether McGirt applies to the other four tribal lands to be determined in an evidentiary hearing that allows appropriate input to occur from interested parties. Every tribe had its own distinct treaty, and every tribe has its own basis for arguing whether McGirt applies. So there really has to be a very thorough vetting of whether McGirt applies to the other four tribes, and so that's just something that we've asked the Court of Criminal Appeals not to decide, given the fact that it needs to have its own unique review.
How many of these cases are you expecting to be appealed?
Well, we're closing in on 200 right now. I mean, our assessment of people in state custody is somewhere between 1,500 and 2,000, who I guess we would say could argue that McGirt applies. There are numerous other cases that are moving up through district courts that we're assisting district attorneys on. So anyway, it's definitely going to represent a burden on our office and on district attorneys. And again, the number is closing in on 200 at this point.
You said that it needs to be reviewed if this just applied to the Creek or to the other tribe. Is it your stance that it just applied to the Creek, or are you still looking into that as well?
So it's my position that a court of competent jurisdiction needs to make a decision about whether McGirt applies to the other 4 tribes. A court needs to make that decision. And so I'm not asking, in fact, I'm asking the Court of Criminal Appeals to not make a decision about that and to allow that to be determined at a trial court, a court that can actually collect evidence and hear witnesses and take full account of whether or not McGirt applies to the other 4 tribes.
How are your negotiations going with the tribes? You early on had some discussions and announced a preliminary agreement, and then within a matter of days, chiefly the Muskogee Creek Nation came out and said, "Well, we're not fully on board with this." Seminole Nation, same thing. What has happened since then? How are those discussions going, and what is this an informal gathering, or are these? Do you intend to file a court action in conjunction with tribes about this?
So, Title 74, Section 18, empowers our office to settle cases, and under that authority, we've had discussions with the 5 tribes that culminated in the agreement principle. So the challenges that tribes have with regard to their constituencies is something that each of them, I think, is doing their best to address in a democratic fashion. So for the time being, I think it's fair to say that there's something akin to a cooling off period while these tribes, their senior members, tribal members, and their legislative bodies discuss this further. But I want to be clear on one thing: the agreement in principle did not spring fully formed from one meeting. There's been almost 2 years of meetings off and on with regard to ensuring that criminal jurisdiction can be restored to the state and occur concurrently with the tribes and the federal government, and then that there can be certainty about any kind of civil jurisdiction issues. So those are the 2 headlines, if you will, from the agreement principle. And where we are is align everybody, again, to spend time with their constituencies to ensure that there's enough of a supply line with regard to, again, their body politic to proceed. So right now I guess I would say that we're sort of on hold, but we're continuing to have discussions with all 5 of the tribes.
You said that this is complicated or confusing. I was trying to find the exact word, but just raises a lot of uncertainty. And I guess kind of depending who you talk to, you get different feelings about that uncertainty. Can you speak to what you believe the potential civil implication in civil, let's talk civil jurisdiction, civil court, everything from taxation to other property matters, things of that nature. What's at stake civilly after McGirt?
Well, one thing is clear, and I believe it's an axiom, that when there's uncertainty with regard to commerce and economic development, that's not good for anybody. And so it's our position that the civil implications of McGirt are going to be a subject of litigation that could have a checkerboard sort of consequence over time. Our view was it's better to have certainty. It's better to ensure that jurisdictional issues are resolved via Congress as opposed to individuals trying to expand, McGirt's application or somehow argue that it has application beyond the Major Crimes Act. So McGirt does not affect real property ownership, doesn't affect oil and gas interests, doesn't affect existing contracts. In order to subject yourself to tribal jurisdiction, there has to be consent. You have to have an agreement that's in the nature of a contract where you're going to do business with a tribe and you're therefore consenting to jurisdiction. The Montana case, which is sort of the hallmark Supreme Court decision with regard to how reservation lands relate to Indians and non-Indians. Number one, there's got to be consent for the tribe to exercise jurisdiction on a commercial basis. And then they can exercise jurisdiction when someone is interfering with the operations of their government. So that's probably more of a shortcut definition. Again, that's a Supreme Court case. The determination of a reservation, by extension, triggers the Montana rule, Montana versus the United States. So what we don't want, again, is the uncertainty that we think is being prompted by the case, because there's really no reservation like this in the country, where you have Indians and non-Indians basically inculcated, doing business with each other, living across the street from each other in a way that we've existed for 113 years. So again, the goal was to address uncertainty, and that if there's a magnetic north of the agreement with regard to civil jurisdiction, it's just to ensure that we don't have uncertainty going forward with regard to how the state and the tribes cooperate and collaborate, and how Indians and non-Indians have responsibilities both to their tribe and to the state.
Do tribal citizens still have to pay taxes under McGirt?
Yes. So there are limitations that with respect to trust and restricted lands. But if you're living outside trust restricted lands, property owned by the tribe, you have the same responsibilities to the state, in our opinion, as non-Indians.
Do we know how many challenges have been approved? The estimation of being like 1,500 to 2,000 could be possible. Have any of them gone forward? Has anyone been released?
No. So there was a case. In Eastern Oklahoma that I'm familiar with. Individual was able to convince a judge that they were Native American. Crime occurred on the Creek Reservation, but the individual was immediately taken into custody by federal law enforcement.
The FBI has also announced that they're going to take jurisdictional lead. I know you had hoped for cross commission before with officers. Is that something that's in play right now or on? So
the Creek is working. The Creek the tribe is working in a focused and result-oriented fashion to try to get cross-deputized arrangements in place with cities and counties within the, 10-county area that comprises the reservation. But it's, there are 10 counties, there are probably 100 cities and towns, and so that process is I would say inching along. But cross-deputization is incredibly important, and I want to say, we have continued to work in a, I think, constructive way with the tribes, particularly with the Creek. For instance, the Creek just approved a compact that allows the Department of Human Services to work with the Creek tribe to address issues relating to deprived children. So under the Indian Child Welfare Act, that sort of arrangement is approved. The tribe retains primary jurisdiction, but working with the Department of Human Services, that allows the tribe to ensure, given the fact that they don't have the bandwidth with regard to social workers and foster families to take care of deprived children. So that compact between the Creek and Oklahoma through the Department of Human Services was entered into last week, and it was a very important step. And so we're working with the other tribes. I think the Chickasaw has also entered into a compact like that with DHS, and so we're hopeful the other three will follow suit.
General, there are at least 5 or 6 whose judgments were vacated. You had McGirt and Murphy, whose judgments were vacated, and I think there were 4 others on that day or the day after who had filed appeals similar to the McGirt and Murphy. So where are they? What's the situation
So
with McGirt and Murphy?
the decision by the Supreme Court isn't self-affecting. I mean, there has to be review by courts in this state. So those are cases that we have underway, and they're certainly cases that we're given a priority.
Well, what do you mean? Like, are the feds going to take those over? I mean, they basically said they shouldn't have been tried in federal court. I mean, in state court, they should be tried.
So they're in the same category of cases that we're working on. As I've mentioned, the over 180.
You say you're going to fight those?
But those are cases.
You say
So
you're going to fight every single one. You're going to refight those?
we're going to require that individuals who maintain that they are subject to and should be allowed the relief that the McGirt decision has created through the opinion in the case. But again, the Supreme Court decisions aren't self-affecting. They have to be referred to lower courts for further action. So we're going to resist, as I said, every case in the sense that we're going to require those individuals to prove up why they ought to be released and why procedural bars that we've outlined in the filing that we're making today need to be taken into account by judges in the state.
Oklahoma's congressional delegation was supposed to be instrumental in helping move some of this along. What is the partners as far as your U.S. counterparts saying now that the agreement has fallen through, trying to be revamped? Is there any word?
Well, I wouldn't say the agreement has fallen through. I mean, we've definitely had some setbacks with regard to people withdrawing from the discussions. And, where we are is all we did was propose an architecture for Congress to consider with regard to addressing both returning jurisdiction to the state on a concurrent basis, criminal jurisdiction, with the tribes and the federal government, as well as addressing any kind of issues around civil jurisdiction. So all that was again, a template, an architecture for Congress to consider. Their commitment, obviously, is that they want to hear from all stakeholders in the state as this moves from an idea to a proposal, actual proposed legislation. So, as I said, I think I would characterize this in a cooling off period. We continue to talk to the delegation on almost a daily basis with regard to feedback that they're getting. But I think the statement that they issued, I think early last week or late the week before, still is their position, that they're interested in working with the state, the tribes, and stakeholders to come up with legislation. Other questions?
Did you get a sense from Chief Hill within the Muskogee Creek Nation or anybody on their behalf, the attorneys, I don't know, why they felt like they wanted to withdraw at this point? I mean, I kind of read between the lines and maybe it seemed like it was a little too early to just go out and say, hey, we're going to make an agreement before some of these, as you alluded to, individual cases or challenges might be brought to see what the ultimate civil scope of McGirt would be. Did they give you any indication? Was that, do you think I'm right in reading between the lines on that?
Well, I'm reluctant to characterize Chief Hill's stated position on, again, withdrawing from the discussions. I think that there was a piece in the Tulsa World, an op-ed piece or opinion piece that I would refer you to, Trace, that I think is an accurate representation, since he wrote it, of his position. I respect his position. I've got to be the Attorney General for all 4 million people in this state, Indians and non-Indians, and I've got to make a judgment about what is best for everybody, both now and into the future. And I don't want this to become some kind of an us versus them thing, and that's been my consistent position since I've had this job. I don't want the 5 tribes and their citizens to become estranged from the state as a result of this. It's important that we continue to collaborate and cooperate. The challenge of governments within government, governments that are, at least semi-independent, is something that's very difficult to work through. But, I'm committed to, as my mother always reminded me, patience is a virtue, and I'm going to exercise patience and deliberation and exercise outreach and conversation and cajoling to try to get, again, the best result for the state writ large.
Last thing from me real quick. Has this been any more difficult owing to the gaming compact lawsuits that have been going on and disputes there? Has that made this more challenging over those last 2 years of discussions, or at least the last year?
It's been a distraction.
There were some statements made from the governor's office that this was an agreement rushed into. Hearing you say this was in works for years, would you like to respond to that?
Well, I'm not familiar with the governor's office issuing that statement, but that's not consistent with the facts. It's not like this was something secret. We were in communication with the governor's office and legislative leaders off and on during this process. It hasn't been sustained. It's been off again, on again. But we've spent, I would say, collectively hundreds of hours trying to come up with, again, something that ensures that we don't have chaos on the back end of McGirt. So again, the idea that this was rushed into, it's just not consistent with the facts.
Has the governor's office reached out to you?
Barbara, I'm sorry.
I'm sorry, has the governor's office reached back out to you on negotiations on the compacts or not?
No, ma'am. Anything else?
I do have one other thing. Speaking of things
Last question.
Complicate matters. Have you had to think through the ethics or any appropriate nature of how do you separate yourself? You have a contract with that involves Mike Burridge, who is I believe is still the general counsel for the Choctaw Nation. You have that contract on the opioid lawsuits. I'm not an attorney. Have you guys had to talk about what you can and can't talk about, or does that pose any dilemmas in dealing with this stuff?
Completely separate cases, completely separate issues. The judge's representation of the Choctaw, certainly predated his involvement in the opioid litigation. He's one of the best Indian lawyers in the state. He was on the other side of the water settlement negotiations, and I think everybody would agree that the outcome of the dispute with the Choctaw and Chickasaw over the waters in the southeast part of the state is something that benefits the state, certainly central Oklahoma, for decades going forward. So as of his involvement of all this is as a voice of reason, as somebody who understands the issues and is focused on getting an outcome that's in the best interest of his client, in this case the Choctaw as well as the state.
Thank you.
Yeah, thank you. Thanks everyone.